First, thank you for coming and welcome. So today we're going to be talking about atomic risk and what happens to nuclear facilities when they are engaged or around an armed conflict and the relevant law that pertains there. So a few house cleaning things to start. Please feel free to use the chat. We've had a little bit of activity there already, and we also have a Q&A feature that you can submit questions. So please feel free to use that. We are joined by two wonderful speakers, Roberta Brown and Professor Tom Dannenbaum. You'll hear a little bit more about who they are and what they will be talking about later. So the reason that we've decided to host this event is there's been a lot of discussion around the Zaporizhzhia nuclear power plant. And so there's a few things to note here. We understand that it's a very hot topic right now. And as part of the American Red Cross, we have a fundamental principle of neutrality that guides our view. And with that, we will be referencing this power plant and we'll be discussing some of the technical implications. However, most of our analysis will be generalized and will pertain to just nuclear power plants in general. However, this is an important topic that's going on in the world right now, so we will give some brief notes on what's going on and the importance therein. So here is a map of Ukraine and its relation to its neighbors. This is helpful for potential radiation leakage and where it could spread and potential for geopolitical issues from that. But that will be discussed a little bit later. So the plant itself was constructed between 1984 and 1995. For reference, Chernobyl happened in 1986, but as Roberta will mention a little later, they're two very different plants that should not be considered in the same way. It is the largest nuclear power plant in Europe and one of the top 10 worldwide. It has 6 reactors. And following the Russia-Ukraine conflict, it has been occupied since March 4th. This raises several issues of staffing and other important issues that need to be addressed with regards to artillery strikes, which both sides accuse her of, and a few other important things. This is an overview where you can see 6 reactors and its location within Ukraine can be seen in this photo. So it's just on the edge of the current occupied territory, but it is under Russian occupation. So without further ado, it's my pleasure to introduce Roberta Brown. She is an engineer that retired from a long career in the electric utility industry. She began her American Red Cross volunteer service on the board of the Delaware chapter and currently an IHL instructor, as well as the volunteer partner for the IHL team, the vice president, service to the armed forces and international service US program, and the SAF director of the Central Atlantic Division. Roberta?
Thank you, Hunter. I appreciate it. As Hunter noted, we're all paying a lot of attention to the current armed conflict in Ukraine, and it's brought just daily headlines about the Zaporizhzhia nuclear power complex. So today, they've asked me to give you a little bit of background on the fundamentals of nuclear power plants and nuclear power plant safety. You should know that right from the beginning, the nuclear industry has always had a defense in depth safety philosophy that guides the design, construction, inspection, operation, and regulation of all nuclear facilities to protect the health and safety of the public and the plant workers. The intent is to prevent at all times the release of ionizing radiation or particulate radioactive material from the plant. Now, you may have seen that the International Atomic Energy Agency, or IAEA, has established 7 fundamental pillars for ensuring nuclear safety and security. They've said that the physical integrity of the facility, the reactors, the fuel pools, radioactive waste stores must be maintained at all times. All of the safety and security systems must be fully functional at all times. The operating staff has to be able to make their safety and security duties fulfill fully, and to have the capacity to make decisions free of undue pressure. There has to be secure off-site power supply from the grid for the nuclear sites, and I'll talk about that in a little more detail later. Excuse me. And there have to be uninterrupted logistical supply chains and transportation to and from the sites. There has to be effective on-site and off-site radiation monitoring, emergency preparedness and response measures. And there have to be reliable communications with regulators. Excuse me. So let's examine the most common type of nuclear power plants, including Zaporizhzhia, to see how a plant works and why these 7 attributes are important. Hunter's put up a slide, an animated slide that you can see a schematic of how a nuclear plant of this type works. Today, most of the world's electricity comes from the use of steam to drive the turning of a turbine, which is attached to a generator, which creates electricity. This energy then goes out on high voltage transmission system to be ultimately distributed to homes and businesses. Now, in most of the plants around the world, to create the steam, a closed system of very pure water is heated to high temperatures. And in most cases, it's from the combustion of a continuous stream of fossil fuels in a boiler. In contrast, nuclear power plants, instead of having a continuous stream of fuel, only need to be refueled every 1 to 2 years of operation. The most common type of nuclear power plants is known as a pressurized water reactor, or PWR. And in them, the nuclear reaction is in a reactor vessel used to change the water into steam by way of a specialized heat exchanger known as a steam generator. Now, the huge reactor steam vessel, the steam generator, and all the piping and pumps containing the radioactive water are contained in a massive dome structure called the containment building. If you look on the slide, you'll see that the steam generator is the large cylinder on the right side of the reactor containment building. The water in that reactor vessel, called the primary system, and it's shown there in yellow, orange, and red on the slide, is kept under very high pressure to keep it from boiling, and it doesn't come in direct contact with the water in the steam generator. Now, the walls of that containment building are made of steel reinforced concrete up to about 5 feet thick. The non-radioactive water from the steam generator, referred to as a secondary system and shown on the slide in blue, is also a closed loop. This water is allowed to boil to create steam, which goes to the turbine to create and generate electricity. Now, power plants also have an additional very large heat exchanger called a condenser, which uses a third entirely separate cooling system with outside water. And it's shown there in the darker blue on the far side of the screen. And it increases the efficiency of the turbine generator. Each of those 3 water systems are totally separate. Now, earlier I mentioned that a nuclear power plant undergoes a planned shutdown every 1 to 2 years of operation to remove or replace a portion of the nuclear fuel. The used, or we call it spent fuel, is still radioactive, but it has a much lower level of radioactivity. It's kind of like taking the coals out of a fireplace, when you're done. It's placed in large water-filled pools for several more years, permitting additional time and reduced radioactivity. And it's then stored in special dry-aired casks on the plant site in most plants right now. Now let's turn back to those 7 fundamental principles of nuclear safety that we talked about earlier. Many requirements, like those concerning industrial security, adequately trained staff, or spare parts, are intuitive, not unlike any facility. But there are other requirements that are a lot more focused on protective measures specific to a nuclear plant. Now, to reduce exposure from any radioactive source, there are 3 primary methods to reduce that level of exposure: distance, shielding, and time. Now, I think you know that nuclear power plants are almost always located far away from major population centers, and they're surrounded by a large, controlled, fenced geographic security buffer with limited access, high security. And together, those provide the distance to assure that what goes on inside the containment building is away from the public. I've already mentioned one other very important feature of design and construction, the reinforced concrete walls of the containment building. One additional advantage of this design is that the most highly radioactive materials are located within that thick-walled containment building. Those thick walls both shield the outside world from radioactive materials inside the building, but they also are designed to protect the reactor and associated equipment inside the building from damage outside. Now, in my personal experience, even back in the 1970s, containment building design was planned to withstand the direct impact of an airplane. So they were already thinking about that type of thing back 50 years ago. Now, the third factor is time. Other ways of ensuring safety are to have redundant safety systems and to operate under strict rules that require the units to shut down under unusual or abnormal events. Now, even when a unit is shut down, though, as long as there's fuel in the reactor vessel, a small level of nuclear reaction continues to make some heat, decay heat it's called. Instruments must continue to monitor essential systems, and pumps have to run to continue to provide reactive coolant through the primary cooling systems at all times. Without this cooling, temperatures could rise, and in the worst case, you wouldn't have sufficient reactor cooling water, and you could have the nuclear fuel uncovered, which would ultimately melt. You've heard the words meltdown before, I'm sure. So this essential electric service to keep the pumps running is normally provided by other units at the same site or via electric transmission lines, the ones we showed before, bringing in electric power from other locations in the electric grid. In addition, in the event of a loss of off-site power, the regulations require that there be emergency diesel generators and the fuel to run them at the plant site. Now, let's look at that last pillar that we talked about, the requirement for effective on and off-site radiation monitoring and emergency preparedness and response measures. I've already mentioned that the design features of distance and shielding, like provided by the containment building, are two of the primary measures to protect the public. The plant operator, though, must also take and report on regular samples of air, water, and biological materials in the local environment to show that there hasn't been any radiation leakage. In addition, working with regulators and local officials, emergency procedures and systems are created and tested with regular emergency drills. In the event of a major emergency, local emergency officials may request people to stay indoors, providing more time. Emergency supplies may include potassium iodide tablets, you've probably heard about, which can be used to block the update of any radioactive iodine, which is a common radionuclide resulting from the melting of aluminum fuel. It does that to prevent injury to the thyroid gland, particularly of children who are the most vulnerable. Well, before we move on, specifically because of recent events concerning Zaporizhzhia, I'd like to go back to that issue on the loss of off-site power. Quoting the IAEA report, the situation in Ukraine is unprecedented. It is the first time a military conflict has occurred amid the facilities of a large established nuclear power program. Now, we know from the IAEA report and publicly available media that there are the 6 nuclear units at Zaporizhzhia, which we saw on the slide that Hunter had up earlier, and 1 nearby fossil fuel plant. The IAEA has confirmed that all 6 units were brought to cold shutdown mode in August, meaning the plant has not been generating electricity, and the nuclear reactor in each reactor has been largely stopped for now over 2 months. There are multiple electric transmission lines providing off-site power to the plant, but there have been repeated interruptions during military activity. We also know that there are emergency diesel generators at the site with at least 10 days of fuel. Personally, I suspect, but was unable to verify, that there may be capability to provide electricity from the nearby fossil-fired unit. And there's been a lot of time since August for significant cooling of the reactor primary coolant and to provide additional electric service by other means. So with the present military activity and access to information, it's simply not possible to know a lot more unless and until the IAEA continues its inspection and reporting. Well, with that background on how a nuclear power plant like Zaporizhzhia works, and now that I've established a few fundamentals, I'd like to turn the presentation over to Tom to talk about the relevant law. Thank you, Hunter.
Hello, thank you, Roberta, for that great technical introduction. So I'm now going to introduce Tom Dannenbaum, who is an associate professor of international law at the Fletcher School of Law and Diplomacy at Tufts University. There he teaches and writes on various issues in international law, including the law of armed conflicts and international criminal law. Tom.
Thanks very much. And thanks, Roberta, for that really interesting and informative presentation on how these systems work. It's a pleasure to be with you today. I have enormous respect for the work the Red Cross is doing, although I should clarify that I'm not affiliated with the organization in any way. So what I'm going to do is speak to three different aspects of international humanitarian law as it pertains to nuclear power plants in context of armed conflict and belligerent occupation. First, I'll talk about the issue of attacks on the nuclear power plant or attacks that might affect the nuclear power plant in one way or another. Second, I'll turn to discussing issues relating to the militarization of nuclear power plants and the vicinity around nuclear power plants. And third, I'll turn to specific issues related to the obligations of occupying powers in context of belligerent occupation regarding nuclear power plants in those occupied territories. Each of these issues appears to be, based on the information that we have, implicated in the situation at the Zaporizhzhia power plant. So the first issue is attacks. And in order to understand the ways in which international humanitarian law protects nuclear power plants and the particular rules around them, it's worth thinking first about the general rules relating to attacks so that we can understand what's distinctive about these particular protections. So some of this will probably be familiar to most of you, but I'll move through it pretty quickly. When we're looking at attacks under international humanitarian law in general, we look across multiple different rules that apply cumulatively. So the first is the rule of distinction, that it's prohibited to attack civilians unless they're directly participating in hostilities, or civilian objects or combatants who have been rendered hors de combat. The important category for us there is civilian objects. I'll come back to that in a moment. That's then layered on by several other rules. First, the prohibition on indiscriminate attacks. So it's not just enough not to target civilians or civilian objects. One also has to specifically and discreetly target specific military objectives. In other words, one can't treat an area in which there are multiple military objectives as a target if there are also civilians and civilian objects in that area, even if it's the military objectives within that area that are the ultimate goal of the operation. Third, even once one has discharged one's obligations under the rules of distinction and the prohibition on indiscriminate attacks, the belligerent party has to engage in precautions, and those are both all feasible precautions to minimize civilian loss, in other words, civilian injury, civilian death, and damage to civilian objects, and to verify the status of the targets to ensure that they are in fact lawful targets. And that's layered on by the principle of doubt that provides that when there's doubt as to an object status or a person's status, that object or person should be presumed civilian and therefore not understood to be a target. And finally, even when all of those rules are complied with, the attack still cannot go ahead if the civilian loss anticipated from that attack would be excessive in relation to the concrete and direct military advantage anticipated. It's important to understand that these rules operate cumulatively, but they also perform separate roles within the regulation of targeting. And it's important in part because the area in which the rules are different for nuclear power plants really relates to distinction. So when we're thinking about the rule of distinction and objects, civilian objects are all objects that are not military objectives. And military objectives that category is defined broadly in Article 52 of Additional Protocol 1, which is applicable in the current conflict because both Ukraine and Russia are party to that treaty. Under Article 52 of Additional Protocol 1, any object that by its nature, purpose, location, or use makes an effective contribution to military actions, such that its destruction, capture, or neutralization would return a definite military advantage, counts as a military objective. And that's true even if it performs significant civilian functions. In fact, it can be predominantly used for civilian purposes, but if it is also used for military purposes, then it counts as a military objective. It's not a civilian object, and therefore on the distinction component of targeting, it would pass that test, and the protection of the civilian interests associated with that object would instead arise through the precautionary obligation to minimize civilian loss and through the proportionality requirement not to engage in attack if the civilian loss would be excessive in relation to the military advantage anticipated. Ordinarily, power plants very often can be these kinds of dual-use objects that therefore constitute military objectives because they supply power to both military and civilian functions. And then the protection for the civilian population arises through proportionality and precautions, but not through distinction. The plant itself would be a legitimate target. But for nuclear power plants, there are a couple of different rules that elevate the protection and change the rules relating to distinction. So preclude the attack as a matter of whether it's a legitimate target before we get to questions relating to the military advantage that might be anticipated from targeting that object. And those two rules are rules around dangerous forces, objects, installations containing dangerous forces, of which nuclear power plants are one kind, and secondly, rules protecting the natural environment. So on the rules relating to dangerous forces, these are codified in Article 56 of Additional Protocol 1. And here, the key point is that the rule of distinction shifts. What constitutes a prohibited target, at least presumptively, is a broader category of prohibition than applies to what constitutes a prohibited target outside of this special category. Specifically, if an attack on a nuclear power plant or a military objective in its vicinity, that's going to be important, I'll come back to that in a moment, but an attack on a plant or a military objective in its vicinity risks releasing dangerous forces, most obviously through a radioactive leak that would cause severe losses among the civilian population, then the attack is presumptively prohibited regardless of the military advantage that might redound from that attack. The specific language is if it may cause the release of those forces. So there's a couple of important features here. First, that reference to may cause the release of the forces suggests that even when there's a relatively small risk, where there is a meaningful risk of that release, then the operation would be prohibited. It's not necessary for it to be more likely than not that that will be the outcome of the attack, as long as there's a significant risk that dangerous forces, radioactive material will be released with the consequence of severe losses for the civilian population, then the attack would be presumptively prohibited. Second point on this first presumptive prohibition, military objectives in the vicinity are also protected. And again, with them, there's an exception for both those and the power plant, but at this presumptive level, they're protected from attack because the attack on those objects could cause the release of these dangerous forces, could cause a radioactive leak with severe consequences for the civilian population. A couple of key issues there. One is what exactly constitutes in the vicinity of the plant. So many commentators focus on the immediate or direct vicinity of the plant. When we're thinking in particular about power lines that are bringing outside power to facilitate the cooling that Roberta mentioned, those could be attacked at some remove from the plant and still have a significant effect on this potential danger. So one question is how to understand that, and the law's not particularly clear on this. I think a purposive reading of the law would say, well, if the attack on those lines risks the release of the dangerous forces within the power plant, then at that point, that would qualify as a military objective in the vicinity, within the vicinity being understood purposively to really be about what kinds of military objectives would cause risk to this particular nuclear power plant. But even if one didn't accept that reading, even if that were not the reading that ultimately proved to prevail, an attack on those lines with a view to undermining the cooling system in the nuclear power plant would itself simply be a form of attack on the power plant. So even if the kinetic action occurred on power lines that were not immediately in the vicinity of the plant, if the consequence was this impact on the plant, and if that was the purpose of the operation, that would clearly be an attack on the plant itself, notwithstanding the fact that the mechanism of the attack is through the power lines. So these kinds of effects, when they are risked, cause this presumptive protection. There is, though, one exception to that presumptive protection, and this applies both to the protection of the plant itself and to military objectives in its vicinity, such as power lines that might facilitate the cooling system, power lines bringing outside power to facilitate that cooling. And that's if the military objective in question provides significant, regular, and let me just find my notes 1 second. And direct contributions to military action. So you need this combination of significance, regularity, and directness in the contribution to military action of this particular object. It's actually very hard to meet that threshold because it would not be satisfied by the power plant providing sporadic or occasional power to military operations. And because it needs to be direct, it wouldn't even be sufficient to show that the power plant provides power to the general grid from which the military draws, which might be sufficient for other kinds of power plants. For nuclear power plants, you need to show a much tighter relationship between the function of the plant and its contribution to military action, so as to establish that it would fall into this category of becoming a target, notwithstanding the fact of its heightened protection. Even in that context, there would still be the precautionary and proportionality obligations attaching to the party that might engage in an attack on that kind of plant or a military objective in the vicinity of the plant. And on top of those specific rules around nuclear power plants, there are also some rules around damage to the natural environment. These are codified in Article 35 and Article 55 of Additional Protocol 1. And specifically, if an attack would cause widespread, long-term, and severe damage to the natural environment in a way that imperils the health or survival of the population, that would be prohibited regardless of military advantage. So again, this occurs at the level of distinction. If an attack would cause, may be expected to cause that kind of outcome, widespread, long-term, and severe damage to the natural environment, then that attack would simply be prohibited as a matter of distinction under Articles 35 and 55 of Additional Protocol 1. And it's very likely that any significant radioactive leak, given the impact on the ecosystem, the impact on human life and its transgenerational effects, would meet that high threshold. So it is a high threshold, but once it's satisfied, an attack can't go ahead, again, regardless of military advantage. So these are two of the key rules that supplement the ordinary rules regarding attacks that elevate the protection for nuclear power plants and military objectives in their vicinity. Let me turn now to the question of militarization. We've obviously heard multiple reports of the way that Russia has used the power plant since it's taking control of the power plant in March of this year, and what rules apply to that use. Well, there are rules of passive precautions. These are codified in Article 58 of Additional Protocol 1, rules around the use of human shields, codified in Article 51, paragraph 7 of Additional Protocol 1, and indeed in Article 82b23 of the ICC statute as a war crime. And the ICC has jurisdiction in this particular context because Ukraine granted it jurisdiction through its Article 12.3 declaration in 2015, the prohibition on human shields, and then finally the question of demilitarized zones. So when we're thinking about passive precautions, the obligation here is conditioned by feasibility. Parties to the conflict have an obligation to the maximum extent feasible, take necessary measures to protect the civilian population from the effects of military operations, including the effects of military operations by the adversary. And that includes, to the extent feasible, separating them from military objectives and not locating military objectives in the vicinity of densely populated areas, but also not locating military objectives in the vicinity of nuclear power plants. And that's specified in Article 56, paragraph 5 of Additional Protocol 1. These, though, are rules of feasibility. It's about due diligence. And so to establish a violation of these rules, you have to show what the party to the conflict could have done alternative to what it did do, and show that it was feasible to take that alternative route. And that means showing that it wouldn't have compromised its military operations to undertake that different approach. And that's a hard level to establish. However, when the party to the conflict is deliberately using civilians or civilian population to shield its military operations or objectives by co-locating them, by using their presence or location to deter attacks by the adversary, and in an effort to render their military objectives or military operations immune from an attack by the adversary, then it's a bright line. That line is the human shields line. It's not a feasibility test where civilians are being purposefully used to shield military operations. That's a clear violation, and indeed, as I mentioned, can qualify as a war crime. And I think it's quite straightforward to show that the use of a nuclear power plant to shield operations or to shield military objectives in that way would qualify for this threshold, because the way in which that shielding deters attack is because of the implications for the civilian population of an attack on military objectives in those kinds of conditions. Now, one of the ways in which many have responded to the militarization of the Zaporizhzhia power plant, the reported militarization of the plant, is to argue for a demilitarized zone. So the first question is there an international legal obligation to provide for such a demilitarized zone? And secondly, what follows from creating such a demilitarized zone if one is indeed created? On the first point, it's difficult to argue that there's a specific obligation to create a demilitarized zone. There is the general passive precautions obligation, as I mentioned, to take the maximum, to engage in them to the maximum extent feasible in necessary measures to protect the civilian population. And one way of doing that could be to create a demilitarized zone, but there are also other ways to do it. So it's difficult to argue that there's a specific obligation to create such a zone. Additional Protocol 1 also urges parties to engage in such agreements around nuclear power plants, particularly in Article 56, paragraph 6, but that's a hortatory invocation. It's not a specific obligation. So it's not clear that there's a specific obligation to engage in this kind of protection, although if one didn't provide for a demilitarized zone, the question will be what alternative measures are being taken to ensure the protection of the civilian population. If the parties do agree on a demilitarized zone, and it has to be by the mutual agreement of the two parties to the conflict, so in this context, Ukraine and Russia, then what would follow from that would be, first of all, that there would have to be an evacuation of troops and military equipment from the zone. There could then also be a monitoring mechanism set up. And the key upshot of engaging in this would be twofold. First, the zone could be expanded beyond simply the Zaporizhzhia plant itself or any nuclear power plant that is at stake in a demilitarized zone. And so it could be extended to include the protection of other objects that are essential to the functioning of the plant, such as power lines bringing external power to facilitate cooling. Second, an attack on a demilitarized zone would itself qualify as a war crime, and the threshold for establishing that would be more straightforward than the threshold for establishing that an attack on a nuclear power plant were a war crime in the absence of a demilitarized zone. So those would be two reasons why there might be some benefits to establishing a demilitarized zone, in addition to ideally the fact that the parties would actually remove military equipment, troops, and there would be more monitoring of the situation at the plant. The final thing that I want to touch on is the question of belligerent occupation. Belligerent occupation applies whenever one state controls the territory of another state without the latter's consent in a way that displaces the latter's authority or capacity to exercise its authority over that territory. It's very clear that we have several areas of belligerent occupation in the current conflict where Russia is the occupying power of regions within Ukraine, and among those regions is the region within which the Zaporizhzhia power plant is located. So Russia is the occupying power in that context. The fact that it's declared annexation of these territories is legally irrelevant. It doesn't have legal effect, and it has no effect on the application of international humanitarian law or the protections under international humanitarian law. That's specified in Article 47 of Geneva Convention 4. So Russia is the occupying power in these contexts. Why does that matter? Well, it matters for a couple of reasons. One of them is related to its positive obligations with respect to safety and health in those zones. And the second is related to the question of labor at the plant. So we think about its positive obligations. Occupying powers have elevated positive obligations to take action to ensure the safety and health of the population under the occupation. So particularly in Article 56 of Geneva Convention 4, there's an obligation to the fullest extent of the means available to the occupying power, ensure public health. Under Article 43 of the Hague Regulations of 1907, there's an obligation to ensure public order and safety. And that's been understood to include ensuring human rights, which would include the right to a healthy environment, would include various human rights that are implicated by possible risks at a nuclear power plant, and is also understood to include preventing transboundary harm. So an occupying power would have obligations to take affirmative steps to ensure the security of a facility like this so as to protect against risks to the civilian population. Secondly, with respect to labor, there are narrow contexts in which an occupying power can require the labor of certain persons in the occupied territory, and two of those contexts are in order to protect public health and in order to ensure the running of public utilities. And so there is a basis, and this is under Article 51 of Geneva Convention 4, there is a basis for Russia requiring the work of professionals at the Zaporizhzhia plant. However, that's limited in several respects. First, it has to be compliant with the labor law in place at the time. Secondly, there have to be fair wages. And third, it has to be only requiring of those workers what is proportionate to their capabilities. So it can't be overworking them in order to ensure the security of the plant. And additionally, if any of the treatment of those workers, and there have been allegations to this effect, if any of the treatment of those workers rises to the level of inflicting great suffering, mental or physical, cruel and inhuman degrading treatment, torture, in unlawful confinement, or the use of hostages, any of those would qualify as war crimes under Article 82A of the ICC statute and under Article 147 of the Fourth Geneva Convention. And so those kinds of mistreatment would be straightforward war crimes. And the fact that there's this authority to engage in required labor would not override those prohibitions. So I've touched on issues relating to attack, issues relating to militarization, and issues relating to belligerent occupation. As you can see, some of the IHL rules, some of the general rules have specific implications in the context of nuclear power plants in armed conflict and belligerent occupation. And then there are also some specific rules that are really tailored, particularly to nuclear power plants, that elevate some of the protections and therefore provide a stronger legal threshold around what would be lawful and unlawful in terms of attacks and militarization. So I'll stop there.
Thank you so much, Tom. That was really wonderful and great to see some of the legal framework there. So we do have some questions for both of our panelists. And also, if you have yet to ask a question, please feel free to do so. And I will make sure that all of our panelists are spotlighted so they can speak when they would like. All right. So, first, for Roberta, we have a couple questions on staffing. So we've seen news stories about stresses on the plant staff in Ukraine and how important, so how important are a facility staff to its operation? Are these people easily replaceable? What are some of the inherent risks there?
Well, let's start out with a little bit of history on this. We know that when these plants were built, they were actually designed, constructed, and operated by Russia. Russian designs, Russian construction, Russian people originally operating them. In fact, I would imagine that most of the people operating them today were once Russian citizens, now Ukrainian citizens. So the question is, could those people be replaced immediately by other people who are currently operating other Russian plants similar to this, or by those who maybe were retired and came back? And the answer is, like most things, it depends. And I guess the analogy I would give is I drive a Volkswagen Golf. Volkswagen Golfs have been around for lots and lots of years. And if I were to jump in a brand new Golf or to go drive an old one, I'm probably going to kind of know where everything is because I know how to drive and I'm driving for a lot of years. But I might not know under stress that on this particular one that you have to turn a stalk on the right rather than one on the left. Or even I had the case this week of having to reset the tire pressure, and boy, did I have to go back to the manual to look because I haven't done that for over a year. So can they operate basically? I think probably yes. But under stress, people are less likely to make instantaneous decisions when something goes wrong. So I go back to my answer is it depends. It would be better without it. It would be better with experienced people. I know in the United States, it takes over a year to train someone. They also undergo significant psychological testing to see how they would respond. But not knowing the specific technical and other requirements for licensure in the Soviet Union and in Ukraine, I can't answer directly. So hopefully the answer is yes.
Wonderful. And also with regards to staffing, do nuclear facility personnel receive training for dangerous situations such as attacks on their facility or other potential issues?
Well, again, I know in the United States that they do. Not only do they train, they drill, and they work on them. I was once as an advisor to the governor of Delaware on an adjacent nuclear plant, and every year we had a drill, and I can guarantee you that when something happened, we were going to have to evacuate, put all of grazing animals on feed, because if you didn't have a drill and didn't drill doing all those things, weren't really being tested. So I know that's the case in the United States. I would assume that some, if not all of those things are true in nuclear plants around the world.
And before we have some quick questions for Tom as well, you mentioned something there that caught my ear about the feed for animals. Can you talk a little bit about why that's something that is important, especially given that a place like Zaporizhzhia is in a major agricultural area in Ukraine?
Well, yes, we talked about time, distance, and shielding as ways to reduce the spread of radioactive materials. But if you have a loss of coolant accident and a core meltdown, not only do you have radiation coming out in the atmosphere, you have particulate iodine 131, has a half-life of about 8 days. And while we're going to protect the children by giving potassium iodide tablets and telling people to stay inside, you also probably have cows out grazing, and cows or goats or other animals that are concentrators of radioactive material. So one of the requirements that you would have to make sure that that milk didn't then contain radioactive iodine or higher levels than were acceptable, you'd make sure that you brought your cows inside and gave them stored feed for a week or two. That would be part of the requirements from the local emergency management people. I know that's kind of a trivial thing, but an interesting tidbit about impact on the local environment in the short term after a loss of coolant accident.
Wonderful. I mean, you always think about the effects on people, and it's important to remember that effects of that kind can also have a major impact on the local population. So now we're going to shift.
But ultimately to people too, Hunter, because the people—
That's what I said, yes.
Particularly children.
Yep. So now we're going to shift to a couple questions for Tom. So it seems that these nuclear facilities are of immense protection in the international realm. So is there a particular reason that the plant in Ukraine is not currently demilitarized or have some legal designation from the international community? Is it a very stringent process, or?
Yeah, so for demilitarized zones under international humanitarian law, you need a mutual agreement between the two parties to the conflict. So the only way that you can get a demilitarized zone as it's understood in Additional Protocol 1 is if both parties to the conflict agree, and Russia's been clear that it's not going to agree. The other scenario where you could have a demilitarized zone that would be imposed from outside would be most obviously through the United Nations Security Council, but of course Russia has a veto there. And so it's actually not that straightforward, legally speaking, to declare a demilitarized zone in this kind of context. In theory, a third state could come in and try and intervene and create one by force, but it wouldn't have the legal authority to do that, and that would of course escalate the situation quite significantly. So the reason that we don't have demilitarization in this moment is because there hasn't been agreement among the parties. And so until there is agreement, there's not going to be a demilitarized zone around the plant. And of course, some of the allegations with respect to Russian action in that space already would appear to violate Article 56 and specifically its obligations under Article 56, paragraph 5, not to engage in that militarization, and potentially, as I mentioned, also violate its obligation not to engage in human shielding. But the reports that we've had across the conflict show significant apparent violations of international humanitarian law broadly. So, you know, the law can only work where there's some normative internalization by the parties. And where that's not the case, then enforcement retrospectively is the most likely way in which it's going to have an effect. But in the short term, it's difficult to bring that effect to bear. Does that answer your question on that one?
Yes, it seems to. So there's a question here on sort of environmental impact on neighboring countries, sort of what I hinted at earlier. And I know you've written a bit on the use of force, and I was wondering if you could talk about if there was a potential meltdown of sorts that had negative effects on the neighboring country, what implications that would have in terms of legally on the use of force or and potential application of IHL later.
Well, so on the application of IHL, the fact that the impact might arise, maybe even predominantly in a certain situation for civilian populations outside of the territory of those engaged in the conflict, that's not likely to be the case in the Zaporizhzhia example, but in a context where there were that transboundary harm and where civilians outside of the parties to the conflict were those bearing the primary consequences of that harm, it's pretty clear under Additional Protocol 1 that that wouldn't change the legal calculation with respect to whether that civilian harm would count in prohibiting the act, and indeed with respect to any remedies that would arise under that act. Those civilians would still be protected under IHL, notwithstanding the fact that they're civilians within a neutral state. With respect to some other implications, as I mentioned, for the belligerent occupier, the occupying power in a belligerent occupation, there is an obligation to undertake due diligence to ensure that there's not transboundary harm. And that would therefore, when failed, when the reason for that transboundary harm was because of a failure to engage in protective measures with due diligence, that would entail a violation by that occupying power against the state that's harmed by that transboundary harm, and even against the occupied state in that context. And so there would be a separate violation, the violation of transboundary harm. The third potential implication would be that under certain circumstances, that transboundary harm could in theory rise to the level of an armed attack that would grant the other state defensive rights against the state that caused that transboundary harm. There we'd start to look more into questions of purpose and intent. And in the current context, there's anyway not that much of a need for defensive authorization, because where there's already an aggression, other states under the law governing the use of force, the jus ad bellum, have a right to come to the defense of the state that is on the receiving end of that aggression. And so the fact that a transboundary harm may then occur in the course of that aggression would not itself be necessary to establish the right to act defensively against the aggressor. If the transboundary harm came from a state that's not the aggressor, or if we're in a context where there's no clear aggressor in the conflict, then the transboundary harm itself could in theory rise to the level of an armed attack that would generate a right of self-defense, but a lot would depend on how the transboundary harm arose and what the purpose was, what the knowledge was with respect to the activities that caused that transboundary harm. But in terms of the impact on civilians, that would be covered under IHL. The fact that it's across a border wouldn't change that.
Thank you. And real quick, you keep mentioning enforcement and violations, and I'm asking this question hypothetically, generally. Is there any mechanism to allow that to be a preventative, or is it only something that can take place after damage has been implicated?
Well, I mean, part of the reason for having those rules and then attaching potential criminal liability to them is deterrence. And that deterrence can happen in real time. So a number of individuals who've been captured in this conflict have already been tried. There are thousands of crimes that are currently being investigated. And so there is a real prospect for some individuals, most likely not those at the very top of the command chain, but there is a not unrealistic likelihood for those further down the command chain that they could face criminal liability down the line. So that deterrent possibility could play a role. But of course, when we're thinking about deterrence, it's about the stakes on both sides of a particular calculation. It may be the stakes of refusing to participate in a particular operation that would be unlawful, may be weightier in that moment than the more remote stakes of facing punishment down the line. Other than that, there isn't a specific enforcement mechanism that would kick in advance. There are additional enforcement mechanisms that could kick in retrospectively. Sanctions, they're already being used quite heavily in this particular context, potentially reparations down the line, but that would depend a lot on how the end of the conflict were determined. But you know, the law in this context operates most effectively where there's normative internalization by the parties to the conflict. And one of the notable things in this particular conflict is that certainly the Ukrainian side has really been seeking to mobilize international law in international fora to generate international support, to bolster any waning support, to ensure that sanctions are continued, to ensure continued military support and so on. And so it's invoking international law to try and support it in its war effort. That's not really a direct way in which the law is being enforced, but it is a way in which the law is informing behavior that then informs how the conflict trajectory plays out. And so one has to be realistic about the limits of law, but one also has to recognize there are multiple different ways that it can play a role in shaping the discourse, in shaping the politics, in addition to playing a role in the courtroom down the line.
All right, so we have a few more minutes for questions. So I'm going to switch back to Roberta quickly. So regarding major nuclear disaster, what sort of spread or range could you expect if a nuclear disaster occurred? You already talked about how it's unlikely and there's a lot of securities in place, but with a major installation like that at Zaporizhzhia, what is the kind of fallout you can expect?
Well, again, the answer is, of course, it depends. And believe it or not, one of the things that's really important is the weather. Depending on how hard the wind is blowing, if it's a calm day, anything that is released from the area will be in the right close to it. If you've got a strong wind, it's going to be dispersed much more widely. But much more widely still has limits too. I saw that one of the questions in the chat was asking about if there were any in-person drills on the calendar. And yes, if you're in the United States, the answer is yes. And if you live near a nuclear power plant, talk to your local or state emergency management agency and they'll tell you when they're drilled, because we have a requirement to have notification sirens and they test them. And they usually tell the public in plenty of advance warning when they're going to be tested so that people know and don't think there is an actual alarm. You know, it's kind of like the things you hear on the radio about emergency alert system. They're exclusion zone in most cases. You'll have a 1 mile, 5 mile, 10 mile area. In some cases, even for very rare things, a 50-mile radius of a plant. But I can look back at specific areas for the worst things that have occurred. And other than Chernobyl, you really haven't seen any significant spread of radioactive material outside the very close to the plant boundary.
Thank you, Roberta. And we'll have time for one more question for Tom. So has this situation highlighted any shortcomings or gaps in IHL? And if so, could you address any of those?
Well, I mean, the most obvious shortcoming of IHL is the difficulty of enforcement, that it really does depend in the first instance on internalization within the military, internalization within various institutions within the state, of understanding these rules as rules that are worthy of compliance because of their normative force, and that normative force being accepted. And so where that's not the case, then the rules will be violated, and it's only through the relatively blunt tool of prosecutions or the even blunter tool of economic sanctions that there's going to be significant enforcement against that violation. But I do want to emphasize that notwithstanding the degree to which this really does seem like a difficult compliance situation, there are elements that are already taking place. So we do have thousands of crimes being investigated across multiple jurisdictions, more trans-jurisdictional cooperation than has ever taken place. There have already been multiple convictions in Ukrainian courts, mostly of lower level Russian troops, but there are also prospects of convictions higher up, and it really depends on the trajectory of the conflict. It depends on political trajectories within the states in question, what kinds of things are likely to happen down the line. But these crimes don't have any statute of limitations. It can sometimes take a significant period of time before individuals are brought to justice. But those laws are out there, and the institutions before which they can be brought to bear on the individuals who have engaged in violations are in existence. And so the systems are there. It's a politically extremely difficult thing to enforce them, particularly when the players in question are as powerful as they are in this particular context. But it's important to neither have an unrealistic expectation of what the law can do, nor to become so cynical as to say, well, it's completely pointless because it's difficult. Of course it's difficult, but as I mentioned earlier, the law is playing a very significant role in this conflict with respect to the way that Ukraine is framing its activities and its engagement with the conflict. And that itself is notable in terms of how it's shaping behavior in that context. And of course, there are challenges more broadly, but I wouldn't want to leave you with the sense that therefore we should throw the whole thing out. It's imperfect. It's a law, it's a legal regime that governs armed conflict, which is itself at the very limits of where law can be effective, but it can have an impact. And we've seen an agreement around grain. Can we get an agreement around demilitarizing the Zaporizhzhia plant? Of course, that depends on politics. There are various factors that would go into that, but it's not impossible.
All right, thank you so much. We are going to be wrapping up here, but please thank you for coming. Thank our panelists for coming. We have a couple upcoming events that we hope you can join us at. So on October 31st at noon Eastern, there will be a Stranger Things in IHL pop culture event. These are always super fun and we always get really into them. So please consider joining us for that. Later that week, we have a prosecution in detention by non-state armed groups event with some wonderful, wonderful panelists as well. So please think about coming out for that. And lastly, if you have any other questions, any comments, any suggestions, please feel free to use that email on the screen and follow up with us then. Otherwise, have a great day and thanks for joining us. Bye, y'all.